I'm Caroline Foote. I'm an advisor at the Tenant Farmers Association and going to talk today about repairing, maintenance and replacement obligations for rented farm holdings. We often get questions in here at the TFA about who is responsible for a certain repair job that might need doing on the farm. Our immediate answer is always that we need to see the tenancy agreement. Although there are statutory fallback positions for some tenancies, the tenancy agreement always takes precedence, so that's what we need to see first. This is because there could be several different repairing scenarios that could be in a tenancy agreement. You could have a full repairing and insuring lease, known as an FRI lease, where the tenant's responsible for everything. The different repairs might be split, some landlord, some tenant, or they might be split 50-50. They might be that the landlord's responsible for the materials, where the tenant responsible for the labour, or those statutory repairing obligations might apply. As I say, they're known as the model clauses. So although they exist, those statutory obligations, they don't automatically apply to all tenancies. So for AHAs, those model clauses will only kick in if the tenancy specifically refers to them, if the agreement is silent or vague on a certain issue, or if it's an unwritten Agricultural Holdings Act tenancy. For FBTs, the model clauses are never automatically referred to. They might be specifically referred to in the agreement, but it's always the tenancy agreement that applies. There's no statutory default position. So the other repairing matter that we often get asked about is if there's a landlord's repair that's outstanding, what can the tenant do about it? So sometimes the tenant might be able to carry out the repair themselves and reclaim the cost from the landlord, and that would be the case if the model clauses did apply. But as I say, we always need to check the tenancy agreement to see exactly what the provisions are for the case of either party not having carried out an obligation. Where the tenant could reclaim the cost, we would always suggest seeking advice in advance, because there's a procedure to follow in terms of serving notice and giving the landlord the opportunity to do that repair themselves before you go ahead and do it. So always give us a call if you're in that situation before carrying out a repair that's not your responsibility. For larger repairs, or ones that are slightly more expensive, or for some other reason the tenant wouldn't want to do it themselves, you can apply to the court for specific performance, which is essentially enforcing that the landlord carries out their obligations in accordance with the contract. Of course, if you are looking to seek repairs from your landlord, you sort of perhaps reasonably have to expect them to be looking at what you might not have done. So looking at whether you fulfilled your obligations before you're pushing the landlord to fulfill theirs. Also, practically speaking, it can have an impact on rent reviews. So if you had a particularly onerous tenancy in terms of repairing obligations, or particularly an FRI lease, it can have quite a lot of downward pressure on the rent. Similarly, if the landlord isn't fulfilling their obligations, that can push the rent down. But on the other hand, if the landlord has taken quite a lot of responsibility for repairs and is undertaking that responsibility, it can have the opposite effect and push the rent up. So we've got some quite good useful guidance notes on the website, particularly about the model clauses, setting out the landlord and tenant's obligations in table form, which is quite clear. But if the model clauses don't apply to you, or if you have any repairs questions, you can always speak to a TFA advisor.